Well, hello and welcome to Forsters panel discussion, Working from Where? I'm Kelly Noel-Smith, one of the international tax partners, and I'm part of the team you have in front of you today. We specialise in providing holistic advice to senior executives with an international footprint, so often coming into the UK or leaving the UK. We cover personal taxes and immigration issues for the employee, corporate tax and compliance issues for the employer, and employment law issues for both employee and employer. We've noticed that the focus of our work over the pandemic has changed. So at the beginning, we were advising people forced to work from a particular jurisdiction because of lockdown. And then as time has moved on, we've found ourselves advising employees and employers on the issues which arise when someone chooses to work in a different place from normal. And we've all seen that some jurisdictions, usually in sunnier parts of the world than the UK, are actively enticing people to sit out the pandemic with them. So we've put together 2 case studies which draw on our experience to give a flavour of the issues on which we're advising, and hopefully to give some practical and pragmatic advice and tips to you and to your clients. If you have any questions whilst we're speaking, please do use the Q&A function, and we'll try to address some of those at the end. And hopefully you know at least one of the team presenting today, so please do feel free to email or contact your questions and we will get back to you. So let's have a look at the first case study. Here we have Rebecca. She usually lives and works in Bermuda, and for the purposes of the UK, she's not domiciled here. She's a director of a company in Bermuda which provides investment services. And Rebecca first came to the UK early in the year to visit friends and family and got caught by the first lockdown. Bermuda's borders remain closed until the summer, and Rebecca is still here in the second lockdown. So Rebecca's UK presence raises a number of questions. First, her personal tax position. Does the time she spent here make her tax resident in the UK? What are the corporate tax issues for her employer? And what's Rebecca's position from an immigration perspective? So let's look first at Rebecca's personal tax position. Well, I'm going to ask John Fitzgerald, who advises from the international private client side of things, to start. John, what would make Rebecca tax resident in the UK? And if she is a UK tax resident, what are the consequences for her?
Thanks, Kelly. So whether Rebecca's resident in the UK will be determined by something called the Statutory Residence Test. The Statutory Residence Test is actually a number of different tests which have to be taken in a specific order. First one looks at the automatic overseas tests. If Rebecca satisfies one of those tests, she'll be automatically not UK resident. If she doesn't satisfy any of the automatic overseas tests, we have to look at the automatic UK tests, which will make her automatically UK resident. And if she doesn't satisfy any of the automatic tests, one has to look at the sufficient ties tests. The sufficient ties test looks at the number of ties or connections that an individual has to the UK and compares that to the number of days that they've spent in the UK. A day for these purposes is being present in the UK at midnight. And the more connections one has to the UK, the fewer days one can spend here without being a UK resident. The Statutory Residence Test also differentiates between people who have been UK resident here in the last 3 years, in which case they're leavers, or arrivers, people who haven't been resident here in the preceding 3 tax year, which is Rebecca's case, as we know that she hasn't been resident here before. So Rebecca will have a little bit more leeway than someone who is leaving the UK, but she could still be resident here under either the automatic UK test if she spends more than 182 days here, or if she's deemed to be working here full time. She could also be UK resident here under the sufficient ties test. For Rebecca's case, the ties that Rebecca will have could be possibly accommodation. If she has accommodation available to her for a period of at least 91 days, and she spends even 1 day in that accommodation, that would be an accommodation tie. Also, if she works for more than 3 hours a day in the UK on at least 40 days, that would give her a work tie. And if Rebecca has these two ties, accommodation and work, she'll be a UK resident here if she spends more than 120 days, which, given the amount of time she's been in the UK, could well be the case. If Rebecca is resident here, the issue will be that once someone is UK resident, they're liable to income tax and capital gains tax on a worldwide basis on all her income and gains. As Rebecca's not domiciled here, she could be eligible for the remittance basis. This would mean that she would only be eligible for her UK source income and gains on UK assets, and foreign income and gains, as long as she kept them out of the UK, she wouldn't be liable to tax on them. She could also be eligible for what's called overseas workday relief, because she hasn't been resident here before. That would mean that she, as long as she kept earnings from employment outside the UK, then she wouldn't be taxed on that. The issue for Rebecca is that because she's been working here for a long period of time, she's likely to have a lot of UK earnings. So the main thing for Rebecca to do will be to check her day count as quickly as possible and work out whether she has already become a UK resident here and what she can do to mitigate that.
Thanks, John. And are there any concessions which might apply to mitigate the impact of the day count on Rebecca?
So the main concession that may apply to Rebecca is the exceptional circumstances concession. This applies where a UK is in the UK for exceptional circumstances that are out of their control, when they would have left the UK but for those exceptional circumstances. There's two main caveats to that exceptional circumstance concession. The main is that it has to be something outside of her control. It can't be that she just decided to stay in the UK because of the pandemic worldwide. So for in the case of coronavirus, the government's issued advice, and essentially Rebecca would have to be here because of the closure of international borders. She's quarantining or self-isolating. She's advised not to travel, or her employer asks her to return here temporarily. The other major caveat with the exceptional circumstances concession is that she still only has a maximum of 60 days that she can disregard for day counting. So if she's been here, for example, since the beginning of the tax year, and up to today, that's now 232 days. So she's still going to have been here for a very long time, even with those 60 days taken off.
Thanks, John. So perhaps more analysis needed on whether the concession applies to Rebecca. It looks as if it doesn't. Perhaps the possibility of some tax mitigation using her non-dom status for general offshore income and gains, and some further analysis to be done to see if she can benefit from the overseas workday relief. So in addition to the personal impact on Rebecca of her presence in the UK, we also need to think about the tax and compliance obligations for her employer company. So I'm turning to Heather Corbin now, one of our corporate tax partners. Heather, could you talk us through some of the key corporate tax concerns that Rebecca's presence in the UK might trigger for her employer?
Thanks, Kelly. Yes, the main concern is that Rebecca is here and that she's a director of a Bermudan company. And so is this, from a corporate tax perspective, going to mean that that company becomes UK tax resident? There's no double tax treaty between the UK and Bermuda, so it's purely a case of applying UK domestic law to the question. And as you probably know, the issue as to whether a company is resident in the UK is primarily determined by where the central management and control of that company takes place, which is usually where its directors meet and make strategic decisions. So normally we'd be saying to the Bermudan company, its directors, make sure that the board meetings are all held outside the UK, there's a majority of non-UK directors, and that anyone in the UK travels to meetings offshore, which of course Rebecca can't do at the moment. So I'd be wanting to check with Rebecca to find out what the scale of the problem is. Is she the only director of this company, or are there other directors outside the UK, and where are they based? HMRC have appreciated that there is a problem for some directors who are stuck in the UK, and have issued some guidance in the same way as John was explaining about what the position is for such directors. They say that if there are a number of board meetings in the UK over a short period, that doesn't necessarily mean that the company has become tax resident here. But it is, and that's in accordance with UK case law as well. But that is only guidance, and I really don't think that we want to get Rebecca relying and the company relying on this. So our advice would be that if there aren't enough offshore directors to form a majority, she should ensure that more, or the company should ensure, and her employer, that more directors are appointed. She should then attend those meetings virtually from the UK, and also the board must very carefully minute all the decisions to make sure that it's clear that strategic decisions are being made in those board meetings outside the UK and not by Rebecca in the UK. Another concern that we'd have in this situation is whether Rebecca's presence here could mean that the company from Bermuda has a permanent establishment in the UK. And for that to be the case, the company would first of all need to be trading in the UK, and then one of two conditions would need to be met. The first is that there would need to be a fixed place of business in the UK from which Rebecca was working. And that's the fixed place of business really requires a degree of permanence to it. And I think that at the moment, it's unlikely that Rebecca would constitute sufficiently permanent presence in the UK for it to form a fixed place of business. And secondly, the other alternative would be if she habitually exercises authority to carry on business in the UK. But again, if she's only here temporarily because of COVID, probably she's not habitually exercising authority. So I think that the risks of her forming a permanent establishment in the UK are pretty low.
Good, Heather, thanks. So some questions to be asked here about Rebecca's role, whether she's a sole director, and a reminder of how important it is to keep good board records and a paper trail generally. Can I turn to Elizabeth Small now, another of our corporate tax partners? Elizabeth, could you comment on the VAT issues for the company?
Absolutely. But first of all, it's also important to remember that there may well be regulatory issues. So, for example, we know as people who have sat loads of exams to become lawyers, you can't just set up and claim to be a solicitor if you just happen to be here because of lockdown. Similarly, there are actually laws prohibiting one claiming to be a doctor, for argument's sake. And also, you did mention that Rebecca carries on investment advisory services, and that rings alarm bells from a regulatory point of view. So all of that will need to be examined quite carefully. But turning to VAT, VAT is agnostic. It doesn't really look necessarily at the type of industry somebody is in and what kind of that profession that they carry on. Instead, it has some fairly odd counterintuitive rules. But I want to bring home the fact that they nonetheless are truly important because VAT affects cash flow. So I'm going to be talking about a fixed establishment, which is similar but not identical to the concept that Heather talked about, a permanent establishment. A fixed establishment is important because if I have a fixed establishment, then I belong in the UK. And that means that there's a real risk that suppliers to the Bermudan company will have to charge plus VAT. And if the Bermudan company doesn't think it makes any VATable supplies in the UK and is not VAT registered, it won't be able to recover the VAT that is charged to them. It will be a real cash flow disadvantage. So, for example, if the Bermudan company was involved in some funded litigation claim and was instructing Forsters, and we were invoicing them a fair amount of money, and council is invoicing them hundreds of thousands, and also there's the question, should there be insurance premium tax being paid? It's going to be really important that that Bermudan company doesn't belong in the UK, because otherwise there could be significant cash flow issues for them. So I'm going to recommend things similar to what Heather recommended, and that is paperwork is always important. It's important to understand why Rebecca's here and why she persists in being here, and to make certain that the company and herself document that. Because a fixed establishment, it requires a degree of permanence. One of the criteria in the HMRC guidelines is you've got to have human and technical resources, but on a permanent basis. And I would argue that inadvertent is not permanent. as a matter of principle, but she's got to be able to demonstrate that it's inadvertent. I would also echo what Heather wisely said, and that is, when in doubt, have more than one director, fundamentally. And I would like to make certain that those important strategic calls that may be taking place with council, in my funded litigation example, that those are attended not only by Rebecca here, but also by the other director who's offshore. So it's important to paint that picture properly.
Elizabeth, thanks. Excuse me. So some good practical tips there, and also again emphasising the importance of the paper trail. Let's bring the focus back to Rebecca. I'm going to ask Alfred Liu now in the International Private Client team to comment on the immigration issues for her, which depend, I suppose, to some extent, Alfie, on whether she has a visa.
Yeah, you're absolutely right, Kelly, and thanks. I mean, I've got London as my background here just to emphasise how important UK immigration issues are for people in Rebecca's position. So the question for her is, on what basis did she enter the UK? She may have entered as a visitor. As a Bermudian national and passport holder, she is able to do that for up to 6 months without first needing to apply for a UK visa, which is actually quite common for nationals of certain non-EU countries, which includes the likes of the US and Singapore, but not others like China and the UAE. So if the COVID lockdown has forced her to overstay in the UK beyond the permitted 6 months, then there are some Home Office concessions that could be available to prevent her from technically breaching the rules for visitors. Which concession would apply to her depends on her when her 6 months of leave expires. So if we currently look at the present situation, if her leave were to expire between the 1st of November and the 30th of November, then she could apply for what is called an exceptional assurance, which acts as a short-term protection against any adverse consequences of overstaying. And what's important is that while Rebecca remains here as a visitor, her permissible business activities from a UK immigration perspective are actually quite restrictive. In my experience, some are actually surprised to hear this, because there's quite a common misconception that visitors in the UK can work here unfettered if they're only here for a short period. And unfortunately, that's actually just not the case. Rebecca can only carry out activities of a general or transient nature. So, for example, attending meetings and conferences, or negotiating and signing contracts. And as an employee of an overseas company, she can also advise and consult employees of the same corporate group, as long as no work is carried out directly with clients. And anything outside of those types of activities really strays into the grey areas, because rather unhelpfully, that there isn't a definitive list of permitted business activities for visitors, and it can be quite industry or sector specific. But in contrast, if she entered the UK on a visa that permits her to work here, then she wouldn't need to be concerned about these restrictions on her business activities while she's stuck here. So the Tier 2 work visa would be the most obvious one that would allow her to work here. But the Tier 1 investor visa, for example, would also allow overseas nationals like her to work here without restrictions. And actually, many of our kind of senior executive clients actually find this more appealing because of the maximum flexibility it offers compared to other types of UK visas. So I guess the ultimate takeaway point, certainly in Rebecca's case study, is that with restrictions on travel that could take place at any moment in a post-COVID world, overseas businesses and employees like Rebecca really need to be much more alive to UK immigration rules and seek appropriate advice, ideally in advance of the employee actually coming to the UK.
Absolutely. Thanks, Alfie. So a really important reminder about making sure our brief includes immigration issues when advising someone coming into the UK.
Absolutely.
So what are the key takeaway points in Rebecca's case study? Well, for Rebecca personally, we've seen we need to think about her UK tax residence position and whether her exposure to UK tax can be mitigated, perhaps through overseas workday relief, through application of concessions, and more generally through her non-dom status, which might help her mitigate tax on non-UK income and gains. As Alfie said, we must review her immigration status. And for the business, we've seen the potential for serious tax and compliance consequences in the UK for the Bermudan company, and how important it is to establish what Rebecca does and does not do, and what her position is on the board, and whether she has any other directors to act with her. And we've emphasised the importance of a good paper trail. What about specific employment issues? Let's turn now to our second case study to see some of these in a particular context. Here we've chosen someone called David, who usually lives and works in the UK. He's head of IT in a UK company, and he can make key decisions for the company and negotiate contracts on its behalf. And he wants to explore the idea of working remotely from a villa in the south of France for 8 months or so, maybe longer. There'll be tax issues to think about, but let's look first at some of the employment points. I'm going to ask Joe Beeston, our employment law specialist, to provide the input here. Joe?
Thanks, Kelly. Well, firstly, I'm very jealous David has the ability to go to south of France for 8 months of the year, but it does give rise to a number of potential issues. Now, there will be potential tax consequences both for David and the company, and others will discuss those shortly. But more generally, there are some wider employment issues to think about. Firstly, employment rights. This arrangement might allow David to actually benefit from local French employment rights. Now, whilst he may be employed by a UK company and have a UK governed employment contract, by virtue of the fact that he is working in France for a significant amount of his time, means he could benefit from those local protections. This would especially be the case if David ends up working in France for more than 8 months a year, or regularly works in France under this kind of arrangement for many years. And therefore, specific rules around working time, holiday entitlements, how an employer can make redundancies, and what payments are due could all apply to David. Now, France is notorious for being an employee-friendly jurisdiction, normally offering far better employment protection compared to the UK. For example, redundancy costs can be around 20 months' pay, far greater than David would be entitled to receive in the UK in the event he would be terminated. And there are also many collective bargaining agreements in France. And these typically tend to be agreements negotiated by the very strong trade unions and apply to whole sectors or sectors. So there could be an agreement out there that applies to senior IT workers, governing things like notice pay and the like, which again David would potentially be bound by. And there may also be a requirement for the company to enrol David into local statutory benefit schemes such as healthcare or pension. So in practice, I should imagine a lot of these issues will only come into play if the relationship between David and the company starts to sour. I'm sure David would be very happy at the moment to work from France, given it's his request, and either not be aware of or be that bothered about these potential French protections. But what normally happens is, fast forward a couple of years, the employer is thinking about reducing headcount, David's name is on the list, David then goes and sees a lawyer, and it's at that stage he starts to realise that actually relying on French protections is far better for me, and then take that angle in order to try and get a better deal from the employer. So whilst these issues may not come into play in practice straight away, they certainly exist, and it's certainly worthwhile the company giving thought to this, because ultimately it can be very costly for the employer in the future. And there's also some local health and safety issues to think about relating to employment. It may well be the case, for example, that under French employment law, where someone's working remotely from home, the employer has to carry out health and safety audits in that person's home to make sure they're set up appropriately. And if they don't, there could be fines and penalties. So again, there's sort of health and safety issues which in the employment context, which the employer may need to think about.
Joe, thanks. So is David under any obligation to tell his employer about his plans?
Good question. I think so, yes. I mean, it's very likely that he will have a clause in his contract requiring him to work in a certain location. Let's assume London. So if he's not going to work in London, then he could technically be in breach by not notifying his employer. So I think on that basis, he should tell them. But also on a more practical level, let's assume David's working at home at the moment because of COVID in the UK. It could be all very informal. And there will be sort of practical issues around, whilst he may not be required to attend the office every day, his employer may want him to come in and attend meetings now and again. And obviously, if he's in the south of France, that could be an issue. So I think practically he'd want to tell them. And I suppose, just for completeness, Kelly, we're seeing lots of employers who are now concerned about employees going overseas and the issues this may create for them, introducing policies which say you cannot work from home, and if you're planning, so you cannot work overseas, and if you're planning on doing so, you need to speak to us first. So David would want to check there's no such policies in place anyway, because he could be, in breach from a sort of an internal procedural perspective in any event.
Thanks, John. I suppose there's business immigration issues to think about as well.
Oh, totally. I mean, I suppose at the moment, let's assume David is a British national. He can work in France at the moment by virtue of being an EU national. But we know that Brexit is fast approaching. The end of the transition period is the end of December. Going forwards, there's a big question mark over what type of approval David would need to carry on working in France if that were to be agreed. That would have to be checked by local French immigration lawyers to work out what David needs to apply for. It may be the company needs to apply for something on his behalf. And as Alfie's already mentioned, whilst many countries have a business visitor route that allows people to go into their jurisdiction and carry out limited activities, it's unlikely that a French business visitor route will allow David to do the kind of work that he's proposing to do. So yeah, very important that immigration issues are checked. And I think sort of probably worthwhile for completeness mentioning that in some jurisdictions, I know South Korea, for example, and I think Singapore, you're unable to apply for an immigration work permit unless you're employed by a locally registered entity. So let's say David was wanting to go to Singapore, unless the company was happy to set up a branch or a subsidiary in Singapore, which will obviously be very costly and have far wider implications, that could be an issue. Now, there are some workarounds, and you can look at engaging local umbrella organisations to be a local employer, but it's not easy, and obviously there will be a cost involved for the company. So it's important to work out whether or not immigration approvals are even possible based on him being employed by a UK company. So we'd have to look into that. And I think thirdly, data protection issues always spring to mind when I think about these types of arrangements. Assuming David is currently in the UK, and the UK company is solely based in the UK at the moment, they'd be processing all of their data within the UK. If David moves to France, then he will inevitably end up processing personal data in France. That could be client data, it could be HR data for the employees who he may line manage. And that means there's a data transfer. We've got data transferring from the UK to France. Now, the company will want to ensure those data transfers are safe and secure. And generally speaking, moving data from one European country to another is pretty straightforward, and that's going to continue post-Brexit. So I'm sure that can be an issue that can be resolved. But if, for example, David in 2 years' time decides he wants to go to Singapore, because that's always been on his agenda, and we've managed to get him a visa, we would then be having data transferring from the UK to a non-EU country, and that's where it can get very complicated, and there will need to be sufficient contracts and agreements in place to comply with GDPR and the like. So another practical issue the company ought to think about. So I think really, Kelly, from my perspective, yes, there are issues the employer needs to think about. We've got the employment rights, we've got immigration issues, we've got data protection issues. And if the employer, having taken advice, can get comfortable that they're happy to let David go to France, then we would be suggesting that's properly documented. So we would want an agreement making it clear sort of what David can and can't do. We would want the right to terminate that and bring David back if we identify issues in the future. And we would want to the extent possible, make David responsible for any liabilities that we as a business may incur as a result. So if we having to pay extra tax, or if there's a local fine for GDPR breach, we would want to try and put that onto David if at all possible. So lots to think about from an employment perspective, Kelly.
Joe, thanks very much, and thanks for flagging some of the quite alarming potential consequences for a UK employer. Heather, does the employer also need to worry about the permanent establishment issues you raised when we were looking at Rebecca in the context of her coming into the UK? What about with David moving out to France?
Thanks, Kelly. Yes, very much so. I think much more so than for Rebecca. So as we've been hearing, David wants to go to France for 8 months a year, probably for a number of years, and he was also able to make key decisions. So I think it's pretty likely that he's going to constitute a permanent establishment in France, which is a big issue for his employer because the corporate tax rates in France are higher than in the UK. So it's going to increase the employer's overall tax burden in all likelihood. There is a double tax treaty this time between France and the UK. So we need to look at that to see whether he does constitute a fixed place of establishment. Again, he will do so if he constitutes a fixed place of business with a sufficient degree of permanence. And since he's going to be there for 8 months, for a year, and then perhaps another year, that seems to me quite likely that it will be permanent enough. And even if he doesn't fall within that test, he'll still constitute a permanent establishment if he habitually exercises authority to conclude contracts in France. And again, we know he can make key decisions, so it's quite likely that he's going to be negotiating and signing contracts there. So I think we're in a situation where potentially there's tax on the profits, both in the UK and France. So the employer really does need to quickly seek some professional advice as to how those profits would be attributed between France and the UK. And also it may be that they can make an exemption election in the UK so that the profits aren't taxed here, just in France. But it clearly needs to be thought about pretty seriously.
Thanks, Heather. So some real concerns there for the UK employer. Elizabeth, are there sort of similar difficulties on the VAT front?
Absolutely. Unfortunately, Kelly, yes, there are. And the reason for that is we get back to what is a fixed establishment from a VAT perspective. And a fixed establishment is a place where there are the sufficient human resources and technical resources to carry out that supply on a permanent basis. And also those human resources, case law will tell us that those human resources have to be of a sufficient seniority and managerial responsibility in order to constitute that. And we know that David, can make decisions. We also know that his intention is to be there for 8 months, but for a number of years to do 8 months. And therefore, this is, unlike Rebecca, is not inadvertent. This is deliberate and a plan. One might say, but why does this matter? And I'm assuming here that the company that David is employed by provides services, IT services to individuals, people like you or I. And that means we have an opposite rule to the one we had for Rebecca, which is now the place of supply is deemed to be where the supplier belongs. It's not where the recipient belongs, it's where the supplier belongs. And we say, but where does the supplier belong? And you'd say, well, of course, there's a UK company, of course, with its headquarters and a staff force in the UK, of course, it just belongs in the UK. But actually, a company can belong, from a VAT perspective, can have a number of different fixed establishments. And it will have, in my opinion, because of David, a fixed establishment in France. And that means that I believe that the company should be issuing French VAT invoices. And so we therefore need to look at taking local advice as to regarding the compliance obligations. Now, customers won't be too off-put at the moment because, fortunately, unlike with corporation tax, VAT rates are the same in France and in the UK. And at the moment, we're all part of the EC, and therefore similar type of rules apply in terms of VAT. So an individual customer won't notice much difference, and therefore it becomes a company obligation rather than kind of a negative sales point. However, VAT rules may well diverge in a post-Brexit world, and so it will become increasingly critical that they look to and adhere to French compliance rules. So there are issues here, Kelly, unfortunately.
Thanks very much, Elizabeth. So very clear now how important it is not only to take UK tax advice, but to get local tax advice to the client. And Elizabeth, you rightly reminded us how important it is to be mindful of the Brexit position, if we could possibly forget. Alfie, could you touch on Brexit here as well?
Thanks, Kelly. Yes, how could we forget it? So as Joe quite rightly pointed out, David, as a British national, will need to think more carefully about EU immigration from the new year, because the current Brexit implementation period ceases at the end of this year. I thought it'd be interesting to have a look at the situation from another perspective, in that David is a French national, and this is why he actually wants to divide his time between the UK and France. In this scenario, I'd be recommending that he apply for either pre-settled or settled status under UK's EU settlement scheme. And he should do this before he goes to France, or certainly before he leaves the UK. And the reason for doing this is that it preserves his EU freedom of movement rights and will effectively differentiate him as an EU national who arrived and has been living in the UK before Brexit, compared to those who come here after it. So it's in his best interest, but also his employers, for him to apply for pre-settled or settled status, because it will enable him to return to the UK without needing to first apply for a UK visa to get back in. And just a kind of one final point for David in this scenario. Let's just say that he is able to get sign off from his employers to work and live in France for an indefinite period. If he ultimately wishes to acquire settled status in the UK, which is effectively permanent residence, he needs to evidence that he's been living in the UK with pre-settled status for at least 6 months out of every 12 months in the last 5 years. So clearly, this could very well clash with his desire to spend 8 months a year in France. So he'll need to adjust his expectations and carefully plan any time he does want to spend outside the UK for this purpose.
Thanks, Alfie. You confirmed that the cut-off period for application for settled or pre-settled status is the end of this calendar year. So how do we advise an EU national who can't make that deadline but wants to continue to work in the UK? Joe, perhaps you could answer that with your employer business immigration hat on.
Sure, Kelly. Well, I mean, there is a potential other option, and it's known as a frontier worker permit. And it's actually quite a new concept that's only been announced by the government over the last few months, and we're still waiting for the detail to be released. We should know more by the 10th of December. But essentially, a frontier worker is a European concept, and it's a name given to those employees who work in one EU member state but live in another. There's lots of examples of these types of individuals in mainland Europe. So you may have someone living in Luxembourg but commutes into France every day for work and comes home. And under the European concept, it's a requirement that the individual returns home at least once a week. So it's someone in practice who'll be coming back every day, but has to come back home at least once a week in order to be deemed a frontier worker and benefit from these rules and this special protection. Now, the UK government has said that it is going to launch a new frontier worker scheme, which will allow EU workers who are currently working in the UK before the end of this month, but do not live in the UK or are not resident in the UK, to continue working in the UK, provided they apply for one of these permits. Now, what we do know is that this scheme is, and the concept of a frontier worker under the UK scheme is far more generous and wider than the European concept. So we are told that in order to apply, the individual only needs to have returned to their home country once in every 6 months or twice in every 12 months. Which means it could capture far more individuals, and it could capture someone like David, for example, if he's living in France as a French national, and he's spending a considerable amount of time in the UK working and only returning home once or twice a year. Conversely, we don't know whether or not the rules are going to stipulate how much time someone has needed to have spent working in the UK, and we're waiting for that to be announced in the guidance. But certainly it's another option available where you've got an EU national who's not resident in the UK, whether that's deliberate or just by chance, but works in the UK and wants to continue doing so. It feels like under this regime there will be another option available, albeit it doesn't give them as much protection as they would have under the settled status scheme that Alfie has mentioned, but at least will give them the ability to carry on working in the UK for the short term at least.
Thanks very much, Joe. So it sounds like we need to watch your space.
Afraid so.
Thanks. So finally, let's look at David's personal position. John, and we'll come back to you, please. Could you tell us about whether David's presence in France is going to give rise to potential double tax issues, so both in France and in the UK? And what do we tell David if he thinks, as so many people do, being non-UK resident means he's outside the scope of UK tax?
Thanks, Kelly. Yes, the main thing for David will be to get local advice in France as soon as possible, because if he's planning to spend up to 8 months there a year, he could well become French tax resident under French domestic law. They look at, for example, his main place of abode or his centre of his economic interest. So they may deem him to be tax resident in France. The key thing for David to bear in mind, though, is that even if he's tax resident in France under their domestic law, he could still be tax resident in the UK as well. We know that David is a leaver because he's spent tax years in the UK. So it's going to be harder for him to break his tax residency. And he'll need fewer connections and fewer days in the UK than, for example, Rebecca, to make him tax resident here. For example, if he keeps a home here and he still does some work here, because we know that he's going to be spending 4 months here, he would be tax resident here if he spent more than 90 days here, because he would still have 2 ties. So there's potential for David to be tax resident in both the UK and France, and that could lead to double taxation because they could both potentially tax his income and gains. In this case, there is a double tax treaty. The double tax treaty will look at trying to determine where David is tax resident for the purposes of the treaty. And once it's determined that, it's called treaty residence, it will then assign taxing rights to certain income and gains to either the UK or France. The problem with double tax treaties, however, is although there's some scope for planning and it can be possible to get double non-taxation rather than double taxation, that they rarely give exclusive taxing rights to one jurisdiction, and they often operate on a system of credits if they don't do that. Whereby if David suffers tax in France, he'll then get a credit in the UK for that tax suffered, but that will often end up in David paying a higher rate of tax. So it will be really important before David makes this move to France to look at get advice on the double tax treaty and work out how it might apply to him. If David is managed to break ties with the UK sufficient that he's non-UK resident, he might look at realising gains while he's outside the UK. He should be really careful about the temporary non-residence rules here, though. So the temporary non-residence rules are anti-avoidance rules, which are aimed at preventing people from leaving the UK temporarily to realising a gain while they're non-resident and then returning to the UK. The temporary non-residence rules will apply where someone is not, their period of non-residence is 5 years or fewer. That's 5 calendar years. So actually, for somebody leaving the UK, they need to be outside for 6 tax years normally, unless the tier treatment applies. David should also bear in mind that if what he's looking to realise is a gain on a UK residential property or a UK commercial property now, he could still be taxed on it even if he's non-resident and stays out and isn't caught by the temporary residence rules. So it's really important for David to look now, how long does he want to spend outside the UK, what sort of assets does he have, and how are those going to be taxed?
Brilliant, thanks so much, John. Well, that brings us to the end of the case studies. We've had a good number of questions coming in, but I'm mindful of the time, so excuse me, I'm only going to take one of those. Alfie, someone's brought up the point I made at the beginning about other jurisdictions beginning to launch quite attractive programs targeted at remote working. Could you give us an indication of some of their key features?
Yeah, sure. It's a good question, and I think everyone's heard about how certain jurisdictions with sunny beaches and sandy beaches and more sun, as John, his background has helpfully kind of showcased in a way, have launched these kind of new visas specifically to facilitate remote working. So the likes of Barbados and the Cayman Islands and Bermuda, for example. I think a common feature of these visas is that they require applicants to have quite a sufficient annual kind of earnings. So, for example, I think Dubai's program has, I think, requires applicants to have an income annually of around 60,000 US dollars. Whereas I think the Cayman, for example, I think it goes up to 180,000 income annually, depending on the size of the family unit. So it's quite obvious that these types of visas are targeted at high earners. But there is a part of me that questions whether applicants would be comfortable disclosing that type of financial information. So it may put off some. But I think on these types of visas, it's important to take away that they are only granted for short-term stays in these jurisdictions for about 1 to 2 years. So they may be right for some, but they're really inappropriate for those who have any longer-term intentions to settle down there. They're really designed for digital nomads and those who are internationally mobile and finding in the travel restrictions with quarantines quite difficult at the moment. But I think they're interesting. I think as remote working is here to stay for the longer term, I think these remote working visas will be here to stay as well.
Fantastic, thank you. Well, I hope we've given you a bit of a sense of the wide-ranging issues that need to be thought about when advising internationally mobile employees and employers, especially in the context of a pandemic plus Brexit. As always, it's a question of look before you leap if you can, and taking advice is key. As I said at the beginning, please do contact any of us if there's anything you'd like to discuss. So thank you very much for joining.